Let me start by the first question, seeking to know whether I'm worried by the interpretation and dangerous precedents, pronouncements being made in the system. I'm not worried at all, because the true position of things is that as executive and then as a government and system, as I've told you, right from 1920, when the first election held in Nigeria to date, legislations were being made, observations made, amendments effected, all out of desire for perfection. So if indeed there are interpretations or perhaps certain precedents have been said that are dangerous, my responsibility is not to worry about them, but to attack and address them frontally. And that is what we have been doing. If indeed decisions are made that we feel they do not support the better policy that will now support the system in attaining the desired result, we now do the needful by way of addressing them through legislative interventions or other options and remedies that are available in the system, which options and remedies are multiple. So the idea of worry does not arise, but the idea of working to ensure that what is best for the system is indeed attained is what matters to me most. The second question is difficulty in referring the legal system. Sorry? Oh, difficulties. Yeah, okay. Difficulties encountered in the system. One thing, the only thing that I think is fundamental for consideration as far as the Nigerian state is concerned, is we have not attained a point whereby we strike a balance between the public interest and individual interest. Here we are, for example, for the purpose of the election coming up in a few days, confronted on a daily basis with hate speeches that have the capacity to now set the country ablaze. Someone will simply sit in the comfort of his room, a kind of sending fake messages, even when he knows, in fact and in law, in all sincerity, it was false and fraudulent, thereby promoting a personal interest to the detriment of a public interest. So the major regret is realizing that most Nigerians do not understand the art of striking a balance between the public interest and the public interest. Public interest, you have no reason whatsoever to subject the life of over 200 million Nigerians to unnecessary trouble on account of your act, all out of claim for freedom of expression. And then when you talk, someone will now say, I am faced with a question on rule of law, that an order is made by a court and then you are not obeying it. Do you now, for goodness sake, promote, support, and establish a right of an individual that is setting the life of over 200 million in danger out of purported respect for freedom of expression? So the major regret, if any, is the fact that people tend to promote individual interest as against the public interest. And until we now come to realize that there are limits to what you can do as an individual, regardless of what claim of right you have, which will eventually affect the collective interest of over 200 million people, until we come to realize that the interest of 200 million Nigerians prevails over the purported freedom of movement, liberty, and expression of an individual, it is going to be a very difficult process and exercise for us. So if there are perhaps maybe challenges or indeed difficulties associated with it, it's a situation whereby, for example, now when we are talking of Naira redesign, for that matter, simply because I have succeeded in raising, perhaps legitimately or otherwise, 200 billion, I can now come out to fight a system that is battling to address transparency, to address visibility of the process out of desire to limit corruption. Is it the limitation of corruption that will now translate to having funds at our disposal arising from the transparency and visibility of the system that can be used in the infrastructural development for the benefit of 200 Nigerians that matters? Or perhaps submitting to the demand of an individual that perhaps illegitimately, unlawfully, fraudulently, deceitfully, perhaps acquire 200 billion, and then he now set aside 100 billion because he has greater noise-making capacity of compromising the press to start blowing rule of law that we will now submit to the interests of an individual over and above the national interest that will now support us in ensuring deepening democracy, in ensuring having in place a corrupt-free society, in ensuring having in place resources that can now translate into infrastructure. So it is about people, limited number for that matter, that have succeeded in having at their disposal resources that they are protecting. And then again, forcing a compromise on a policy that is beneficial to 200 million Nigerians. Our interest is not to a fraction but to a whole. And the whole is the Nigerian population of over 200 million and not limited number of individuals that feel a policy should not stand simply because it does not accord with their desires and with what they expect to see operating in the system. So that is my take on that. And then the financial autonomy, why is it difficult to achieve? The compromise, I have just raised an issue of an individual forcing his way over the majority on account of the resources at his disposal. So it is about, when you talk of autonomy and you talk of finances, it is all about the finances. The answer is in the question. You talk of the financial, you talk of autonomy. Then here are people that believe in one way or the other, their finances are going to be compromised, or the volume of finances at their disposal is going to be limited, and they fight it. So that is the issue. But the true position of things is it is difficult because the compromise, because of the fact they will end up having the volume of the finances and funds available at their disposal compromised. But then ours is to ensure things are done, and then arising therefrom, we took steps to effect constitutional amendment to Section 123 of the Constitution to ensure the autonomy of the legislature, the autonomy of the judiciary, and we further supported it with an Executive Order number 10. And we are doing, and will continue to do, to ensure at the end of the day that the system works efficiently, and indeed, the system works efficiently. We will continue to do it. We will continue to push by way of legislative framework, by way of executive intervention, by way of political interventions, among others. Which one is the next one? Breach of court orders.
Corruption.
Well, corruption and in the system, I do not think corruption indeed is exclusive to the judiciary. It's all encompassing, all forbidding in the system. But the true position of things is, without being exclusive and restrictive in consideration, what we are doing in terms of the fight against corruption is all encompassing. Both in terms of institutional interventions, you have institutions like EFCC, ICPC, the police are there, and Code of Conduct. They are all there by way of institutional intervention to ensure that corruption is reduced to the barest minimum. Again, in terms of actions and enforcement, we are taking steps to prosecute, and that prosecution has been ongoing to such an extent that as at the time the EFCC was established, I think around 2003, or up to around 2015, they had to their credit, a record of conviction of around 106 106 convictions. But only this year, I'm talking of 2022, they have over 3,000 convictions. So that, in essence, establishes a point that we are making progress. We are recording successes as far as the fight against corruption is concerned. But that has further been consolidated the more by the international recommendation and commendation accorded our president on account of his appointment as the champion of anti-corruption by the African Union. And that was further reconsolidated by international bodies, inclusive of United Nations Office of Drugs and Crimes, which equally assessed Nigerian corruption index and come to the terms with the reality that among the 17 establishments and institutions assessed in terms of corruption, 17, there has been a tremendous percentage of success and enhancement in the success associated with the fight against corruption in respect of 15. So regardless of the dimension and the way and manner you look at it, we are making and recording huge successes. And that can further be visibly seen arising from what we have been doing in terms of recovery of illicit funds. We have a record, first, of recovering over $322 million in 2017, which set the foundation of what we are witnessing today as the effort of the president in taking people out of poverty by all the establishment of the social intervention programs. So the $322 million were applied in frontal attack of poverty and ensuring the support for employment in the system. We equally recorded further success as far as the fight against corruption is concerned by way of deploying additional $311 million recovered, recovered and repatriated on infrastructure, which funds were indeed applied in the completion of the second Niger Bridge, progressing with the work on Abuja-Kano Expressway and Lagos-Ibadan, among others. So regardless, and then if you are talking of prevention, I have demonstrated to you how the Money Laundering Prevention and Prohibition Act came into place, what we have done relating to incidental legislations that were put in place, proceeds of crime bill, and a lot of other legislations. So regardless of the way and manner you look at it, we are doing the needful in terms of the fight against corruption, not only within the judiciary, but in fact within the system at large, by way of having institutions associated with the fight against corruption and supporting them to perform, by way of having the necessary and relevant legislations, by way of indeed having in place policies that have translated into enforcement and prevention of corruption, among others. So that is my take on it. And more so, we equally come to realize the fact that as far as the judiciary, if you want to take it in exclusivity is concerned, there is need to ensure that someone is adequately equipped for the purpose of performing. You give someone and expect much from him. So with that in mind, we equally have taken steps to ensure that the welfare of the judiciary is enhanced, and then Mr. President has given approval in principle for the enhancement of the welfare. And again, a further process associated with the transparency and integrity of the system is being deployed in terms of recruitment of judges to such an extent that agencies of government, including the anti-corruption agencies, are involved in filtering and clearing officers aspiring and vying to be judicial officers. So a lot of policy decisions were generally broadly brought to bear in terms of the fight against corruption, generally, and then exclusively as far as the judiciary is concerned. So we are doing what it takes in terms of ensuring the integrity, quality, and the efficiency of the system generally, with particular regard to the scourge associated with corruption. Now, on the issue of corrupt, I think it's answered, right? I believe I'm done, right? Thank you very much. Within the context of what constitutes a rule of law in the Nigerian situation, where an order is made by a court, you have multiple options. But let me state, before even addressing the issue of the options available at our disposal as a government, the fact clearly that we are not in breach of any order made by the court, inclusive of any order associated with the Naira redesign. We are not in breach. I believe, I'm not a banker, but you have not gone further to establish which bank is it that you have gone to present a 1,000 or 500 Naira note that has been rejected. So we are not in breach. So, but then assuming we are in breach, the fact remains that this matter is sub judice, as you rightly know, it's been contested before the Supreme Court, and when an order is made, you have multiple options within the context of the rule of law. One, you are entitled as a matter of right, if the facts and evidence support your position, to apply for setting it aside. The position of the law, legal jurisprudence is clear. Once you are attacking, and then seeking for a setting aside of an existing order of the court, you cannot be said to be operating in breach when you presented your application for setting aside. If the court is not an apex court, you equally have a right of appeal and support the right of appeal with an application for stay of execution order. So the bottom line of what I'm trying to state is the matter is sub judice, and within the context of this rule of law, we are doing the needful as a government in terms of ensuring that the right of the government within the context of the Naira redesign is being protected. So we are not in breach. Well, generally speaking, anything that has to do with judgments, orders, is a function of the judiciary. And I believe you very well know that Attorney General of the Federation is indeed, belongs to the other side of the divide, the executive. But notwithstanding, I will make an attempt to give you an idea as to what is being done arising from the collaborative understanding between the executive and judiciary with particular regards to the issue of conflicting judgment and orders. It became a source of concern over time, and then arising from that concern, there was indeed an engagement between the executive and the judiciary, and that gave rise to a lot of interventions, about 3 of them that I can readily remember. The first one is a practice direction issued by the judiciary, and the essence of practice direction is to bring about an order as to an uniformity and consistency in the way judiciary does its things in terms of proceedings. And then again, as you rightly know, some of these judges and justices that were alleged to have indeed issued, and deliberately for that matter, with impunity and arbitrary conflicting judgment and orders, were disciplined. And some were, I think, at a point even dismissed, right? Either the idea of discipline was equally certainly factored to mind and pursued by the NJC. And again, I believe arising from that concern, the technological component consideration by which the judiciary took steps to have justices commonly and jointly online to ensure minimization of conflicting decisions and orders was equally deployed in the judicial system. So what I'm saying in essence, yes, there was concern associated with conflicting judgment and orders. 2, the concerns were indeed noticed, and then 3, collaborative actions were taken between the judiciary and the executive with a view to address concerns associated thereto. Now, the issue of constitutional amendment, I think. Your question was what other things have been done in respect of, sorry, come again, please. Yes.
We're talking about consultation for amendments. So I wanted to know what more are you going to see in this amendment aside
the possibility of, making time of essence considerable factor in, as it relates to election and electoral processes is factored into constitutional amendment being processed at the National Assembly. For example, as to whether if indeed you are supposed to file an action within 14 days. We are supposed to file an action within 21 days, and then there are force majeure associated with natural disasters, something like COVID that came about, and that makes it impossible for you to now file within the 21 days. As to whether time begins to run, even while the supervening natural events were there, whether time should begin to run or it should not. And I think the proposal being considered by the National Assembly is to the effect that time will not run during such period of supervening impossibilities. So what you expect to see arising therefrom is a situation whereby the supervening impossibilities, particularly the natural supervening impossibilities, can now be factored into consideration into the time calculation, time consideration. Yes, and then the open rebellion that was raised as an issue relating to Naira redesign policy. First, let me start by way of linking the Naira redesign policy to the ownership spirit associated with election. I tried to explain in the course of my submission that some of the provisions introduced into the Electoral Act were intended to ensure that Nigerians take effective ownership of their election process by way of ensuring that no foreign funds are allowed to influence our decision in terms of ownership, and by way of limiting the idea of, the contributions by Nigerians to the political parties. So if you are to consider extending it further, perhaps a situation whereby Naira redesign is factored into our electoral process consideration, it could equally have the possibility of ensuring that money is not allowed to play a prominent role in affecting the freedom of judgment of Nigerians. So it is about a policy, and a policy is intended, one, generally with particular reference to Naira redesign, the intention is to, I talk to you equally about Money Laundering Act, which is intended to bring about the greater visibility and transparency in what we do in financial sense. So the policy associated with the Naira redesign has a lot of advantages. Advantages associated with the fight against corruption in terms of bringing about the desired visibility and transparency. Advantages associated with sustenance and allowing the freedom of judgment of Nigerians to prevail. Freedom devoid of monetary inducement and interventions is equally part of it. But then, on the issue relating to the open rebellion, as you characterize it, one, I would like to comment more in view of the fact that the sizable portion of such considerations constitute a subject matter of litigation before the Supreme Court. But above all, as you rightly know, you equally raise issue of treason or perhaps certain undertones associated with it. These issues are usually issues that are issues of process. So you cannot rule out the possibility of investigation, but the responsibility of investigation and doing the needful arising from the weight and assessment of the implications of the statements and utterances is the responsibility of security agencies, and I believe they are doing the needful in that respect to determine whether there is need for further action. Actions associated with investigations, actions associated with prosecution, and what other measures needs to be taken in case it is their conclusion that there is need for actions to be taken relating to the utterances made. So that is the best I can say in that respect relating to open rebellion. Now, the last question, I think, it was about deficiency of prosecution, notwithstanding the robust laws that are in place. Well, the idea of prosecution, honestly, is something that you need to understand that is a function of, first, perhaps maybe a complaint, 2, investigation, 3, gathering evidence and profiling same for presentation before judicial process. So it's not a kind of, it's a process that is indeed loaded with a lot of component of consideration, other components relating to the executive, the judiciary, among others. But the true position of things is, as a system, we have been doing the needful in terms of prosecuting people that are presented, that are indeed where there exists a prima facie allegation of commission of electoral offenses in view of the fact that the laws are there. And out of desire to further enhance the quality and the reach associated with prosecution, the Office of the Attorney General has generated a fiat investing the powers in the state attorneys general to prosecute offenders in their localities. So notwithstanding having in place the laws, we equally consider the possibility of a collaborative approach by which the powers of the Attorney General of the Federation are donated to the state attorneys, all out of desire to ensure at the end of the day that regardless of how remote and where the offense is committed, something is done in that direction. We have a collective responsibility to ensure that this democracy works, and then arising from that realization, we are doing the needful. But I have told you earlier, over time, what we have tried to do is to be fine-tuning our legislative framework. So if, for example, the need has arisen perhaps to have to have tribunals or things of that nature, there are things that one cannot rule out the possibility of considering. But the truths of the matter is we are doing the needful, we will keep improving, we keep working until we get to the promised land in terms of having a perfect election. But I believe, and certainly so, that you will agree with me that what we had in 1999, what we had in 2003, 2007, 11, and 15 is certainly different from what we have in terms of the quality of our electioneering processes. So we have been evolving, we will keep revolving, and we will keep attaining. Thank you very much.